Okay, good morning, everyone.
Good morning.
Thank you for joining us today for the title panel. We have today Annie Fan from Chicago Title, Nancy Chan, Lawyers Title, Marcus Jacques, Western Resources, and Yolanda Martinez-Arenas from WFG Title. And so we're going to be going over some important questions with title insurance. So first I'm going to start with Yoli. Yoli, why is it important to submit the SI early in transactions?
Good morning, everyone. The SI, which we refer to as the Statement of Information, or sometimes we might refer to it as the GI, General Index. We have to run this on all sellers on a sales transaction and on a refinance, all borrowers on title. It is a document that people may say that it's not that important, but we do need to have it submitted in as soon as possible, because it's not just what's recorded against the property that the preliminary report shows, but it's also what's recorded on the principals, the people on title. If they should have a federal state tax lien, if they should have a child support lien, DA lien, or maybe a judgment against their name, then whatever's against their name is against any or all properties that they own. And a lot of times, we don't get that SI in until, I know that doesn't happen with any of you, but sometimes the title company receives the SI when escrow sends the deeds to us to send down to the Hall of Records the next day. So then there we are, searching the SI the night before recording, and then unfortunately, if a lien pops up, we gotta pull the recording. Especially what's been going on during these hard economic times, it seems like more and more judgments and liens come up on these particular times. So it's always good to know what personal judgments and liens against the owner's name up front, so that you as the realtor have more time to clear it. And I know people think, well, we're in a modern technology era, and that is correct, but it still takes a human person to look over every single name to check to see if that lien is theirs. In a case of, like, if it's Bill Smith, we have to run every variation. Bill Smith, Billy Smith, William Smith. It's fine if it's not a common name, but if it's a common name, we get hundreds and hundreds and hundreds of pages of liens. And we have to prove that it's not your client, and that's why we need the SI. I've had transactions where police officers or sheriffs, they do not want to give personal information for their safety. I understand. If it's not a common name, obviously it's a lot easier to work with, but if it's a common name, it's a little bit harder, and we have to kind of work with that. I also had a transaction with an FBI agent who said they absolutely cannot give information, so it's like, okay, we're working off the name and the address that we have. And title companies will work with it on a case by case, but basically, it's to the benefit of your client that we get that information to clear, in a lot of cases, to prove that it's not their lien, and especially if it's a common name. So it's still very important. The sooner we have it, the sooner we can clear it, or at least if it is your client's judgment, the more time you have as a realtor to work with and clear that.
Okay, great. And just to clarify, the SI, when she says SI, she means Statement of Information. If you don't know the SI term, it's just a form that people put all their information on, so that we can cross-reference any detail in their history. And the GI is a general index, index of all the documents. So all the documents we're searching. Annie, what is a child support lien?
After the divorce, the court will pretty much determine one party is responsible for the child support payment. So the child support lien will be, let's say, when you get divorced, then there's a child support, you start having been paying that, and when you want to sell the homes and refinance the homes, it's going to show on the preliminary title report. So the escrow officer has to draw demand, contact the court to find out if the payment has been in full and current, and if not, the seller or the borrower has to pay, then the escrow will draw demand and then get the release. So the lien will be removed.
Great, thank you. Okay, the next question's for Nancy. I know she's ready because she's got her Lee's coffee right there. Ready all day. Nancy, what is an easement?
Easement, we get that a lot, especially right now that we have a lot of builders, people doing renovation, people adding on to their properties. Easements are, the definition of easement, not word by word, but just for you to understand, is you own the land, someone else has the right to use certain portion of the land for a certain specific purpose. Okay? You're paying the property tax, but there's certain part of the land is used, for example, the most common is the utility easement, which is Edison. Your cable company now is attached onto the Edison company, and there are the flood control easement. A lot of property, you see that flood control right behind you. There an ingress and egress easement, that means in and out easement. There's an alley or there's something that certain people are using it to go through that property. When you have that easement, it's put into your preliminary title report under exception. The reason it's under exception is that we're protecting everybody, saying these are the ones that other people has the right over your portion, certain portion of land. And we're disclosing it, just like your NHD, your disclosure, we're disclosing it to you, and also the buyer has to sign and approve. So they understand what they're buying, what are really on the property besides the building they see and whatever. And so one thing that I caution a lot of realtors, do not explain easements to them. If they have a question, they could call the title company direct. If you have let's say you have just a single family home, and your buyer says, you know what, I want to add on. I want to build a pool. I want to do this and that. Most important thing, now they're what? They're telling you their intent. So you need to go to the title company, whichever that you're using, to say, I want all the easement documents and I want the easement plotted. Easements are itemized in the prelim, but they don't give you the actual document to read. None of the exception, they give you documents to read. You have to order it. Title company, all of us will be very happy to give them to you. The plot easement means they're going to draw another map from the plat map, and if there's 5 easements, we're going to itemize them by numbers, and we're going to color code it. 5 different colors, and we're going to draw it out on the map for you. That's engineering. It takes longer. So have patience, read the prelim ahead of time. You just have to be communicating with the title company you're working with to make sure that we know what to provide for you. So does that means as an agent, we as a title company, we're doing the disclosure for you, we're really protecting you. Thank you.
Thank you, Nancy. All right, now, next question is for Marcus. Actually, we haven't seen him on a panel for the last 2 years because he was the affiliate chair. So Marcus, what is an uninsured grantee and what are its pitfalls?
This is a topic that I've been dying to get out, and I'm sure that my colleagues have been dying to get this out. Let's explain it. I'm going to explain it to you in a case situation. As you know, when a person takes out, when they purchase or when they refi, they have to get something known as title insurance. That insures the transaction, and it also insures any loan being secured onto the property. That's the time that you need title insurance. So let's give you the case, the classic case of Mr. and Mrs. Lee who bought a home. When they bought a home, they purchased it with finance money, so they had the title insurance that was given to them by the sellers to clear up everything that the sellers had, and then they also had the insurance for the policy that they needed for their loan, okay? They live in it for 5 years, and did I mention they have an older son named Lawrence? They decide, because their relationship is rocky, they decide to deed over their property, take themselves out of it, and quit claim it over to their son, okay? At that instance, when they've done that, they've done a transfer without insurance. So it's known as an uninsured grantee. Now, what are some of its pitfalls? First pitfall would be anytime that the tax assessor, and we've heard it here when the tax assessor has spoken to us, anytime that there is a transfer on a property, it makes for what the tax assessor would call an assessable event. So they may look at the property, who it's owned by now, and they may reassess the property taxes. That's one pitfall. But here's the other pitfall, and this is how it happens in real time. As I said, the Lees were having a rocky relationship. They grant deeded it over to their son. They used a quitclaim instead of a grant deed, okay? The son was 20 years old when he got the property. Shortly thereafter, Mr. Lee takes off, moves to Taiwan, somewhere in Taiwan, undisclosed. We don't know where he is. We never hear from him again. So now, it's 5 years later, Lawrence has now gotten married, and his mom has been living with them, but they find a bigger house and they want to move, okay? So now we open up, they sell their home, we open up a title policy. What do we see on there? We see that it was transferred outside of insurance by Mr. Lee, and Mr. Lee, mind you, is still on the loan that they still owe, okay? So even though he transferred himself out of title, he's still responsible for that loan, right? We have what is known as, we need an affidavit of uninsured grantee. We need his signature to say that when he transferred it outside of insurance, he was doing willingly and without any compensation. Well, what do we have here? We don't know where to find him. So we have a block on title, pitfall number 2. Not only that, here's another pitfall. Lawrence has gotten married, and his relationship, like father, like son, is on rocky. He's on a rocky situation. He's now divorced. He's now divorced, or in the process of divorce. Because we live in a community property state, we also need his soon-to-be ex-wife to sign off her community rights. So there's many pitfalls when you start transferring. And it's something that we need to clear up at the time that we issue a policy. I'm sure you can ask any one of us, but here's a real classic one that we just had. I want you to remember Coco Segovia, the Coco Segovia instance. We have a title insurance that we're willing to insure for this gentleman who was recently divorced. And we see that there's the property's been deeded out, or it's been quitclaimed out to Coco Segovia. They put Coco Segovia on it. We asked the gentleman, who's this Coco Segovia? He goes, that's my dog that went to Argentina with my ex-wife. So before she took off and divorced him, she transferred the deed over, and she put Coco Segovia on the deed. So that should be a lesson you can ask any one of us. I'm sure that we have some horror stories. You're always going to be asked, I'm sure everybody here can tell you, you're going to be asked by your clients at one time, what do I do to put my son and daughter on title? That's something they need to take up with a professional. They need to look into a trust, and they need to understand the pitfalls of just doing that haphazardly. Thank you. Sorry for taking so much time.
Okay, we forgive you. Yeah, so ask your clients if they've done anything before you're starting to put your property on the market.
That's one rich dog.
Coco's a
Where Coco is.
Where's Coco?
It's somewhere in the Pampa in Argentina.
Okay, Annie, what is supplemental tax?
Supplemental tax is not the property tax. And when you do an ownership changes, or if there's a new constructions, the assessor's office, they're gonna reassess the properties and to find out what the improved values. And supplemental tax, when you receive the bill, there's no really a length of the timing when you're gonna receive it. There's no set day, so it's not once when they assess it, within a month you're gonna receive it. Sometimes it's months. That's pretty much.
Yeah, and that's once you pay it, it's done until you do something like that again.
It's a one-time assessment when you do the transfer. Yeah.
And, okay, Nancy, the next question's for you. How does the title company handle properties that are in a trust?
Oh, we get them a lot now. And that's what Marcus was saying. If you really want to protect your asset, there's tax benefit to having a trust. And also, it prevents a probate. When somebody dies, if there's not a trust, even if there's a will, it will have to go to probate court to authenticate the will. So there is what? Time. It takes longer if you want to sell the property. And also when you go to probate, there's a very hefty cost. It's not free. The court charges you. And you also have to hire an attorney. So when you really want to protect your asset, you want to give to your children or protect it from somebody else, it's good to go to a trust attorney that specializes in that kind of, you're not going to the bodily injury attorneys, okay? And I like LegalZoom and all that stuff. It's fine. It's not funny, because I've seen people do it. Somebody gave me a trust that was like 3 pages, and the verbiage was wrong, and they just downloaded a form and they fill it out themselves. It doesn't work that way. And the $300, $400 attorneys, they don't know, they're not talking to you. They don't understand your family situation. They don't really identify your intent. That takes counseling. So when you do a trust, you're giving the property, your assets, into an entity. When you grant it in a trust, there are tax benefits, it protects your heirs, and you can specify who's going to be in charge of the trust. Look at the Rockefellers, the Mellons, the Gettys. What do we call trust fund babies? We all know they get money from their ancestors so they can live on. And it's the same thing. Even though you don't have that kind of money, for whatever you have, the trust provides a protection to protect your asset. And so you don't get people to fight after you're dead, even though you don't know it, but still, I mean, that really is. And you assign somebody to be a trustee of the trust. So let's say if Nancy Chan has a trust, and I happen to die young. Let's say that I just passed out today, drop dead right here. You have to save me.
God forbid.
You have to save me. And so, but if I have kids who are underage, I can, in the trust, it stipulates who's going to be in my place. Successor of the trustee to take care of my trust and my estate. So if anybody that wants to say, I want to put my son, 2-year-old, the Asian does that a lot. I want my son that's 2 years old. I get this call every day from my agents. I have a son that's, the father's in China, the wife is here with the 3 kids. They want all four people on title. I said, how old are the kids? 3, 6, and 8. It doesn't work. The kids, putting them on title, you're going to get all kinds of problems. Like putting Coco Segovia on title. It's the same thing, okay? So go to see some really good trust attorney. They specialize in them. And when we take care of them, we will want to know, you bring me a copy of the trust. Title company will require trust. If somebody's dead, we will need an affidavit death of a trustee. A lot of times the successor will come in and take care of it. Also, we need a trust certification saying that the trust is as it is, it hasn't changed. So these are the 3 things you should have. And tell your client when they do a trust, keep it in a safe place. You don't know how many times it goes into escrow. It happened to Kathleen, it happened to Kathleen Mueller last time. They couldn't find the trust. The kids cannot find the trust. The father put it in such a safe place, nobody knows where it is. So they went through his 2 homes and went through everything, and nobody wants to do that. So we finally found it. So, but those are the things when you take a listing for a trust, that's the thing you ask. Where's the trust?
Okay.
Okay, and I think Marcus wants to say something.
I wanted to say something, and when usually the objection is, as Nancy was saying, when people want to put it costs money to put stuff into a trust, but it's money well spent. It's going to run anywhere from $1,200 to like $2,000. But compare that $2,000 to $7,000, which is automatically out the door to retain a probate attorney.
one more thing I know, this is a really good topic, and Nancy and Marcus both hit on it. It's important that you get a good attorney. Right now, I have a transaction. The attorney drew up the trust. It was dated in 2002. I saw the trust, but guess what the attorney forgot to do? He forgot to deed the property, record the deed into the trust, okay? Oh my gosh. So if we don't go now probate, because it's still in such and such name, then there's such a thing as the Hedgestead proceedings, which you have to still go. It doesn't go? It doesn't. No more. Okay, well then see, now you do need to have a good attorney and make sure that the property is not only drawn the trust up and signed it, but it also has to be vested and deeded into, recorded into the trust. And I've seen that too many times. A good attorney, don't be cheap.
And no, we cannot waive the requirement of reviewing the trust. People have asked that before. I'm not going to waive that requirement. Okay, really quick, we really need to, no more stories. We're running out of time. No, I mean, we're really running short on time today, so. Yuli, what is an unsecured property tax lien, and when does it occur most often?
Okay, an unsecured tax lien is a tax lien that is not secured to any real estate or on the tax roll. This is common. For an example, right now, while working with a lot of investors, they buy a property and they fix it up real fast and turn around and sell it 2 months later to a third party. What happens is the tax assessor, the investor didn't give the tax assessor enough time to reassess from when the investor purchased it. By the time the tax assessor gets around to reassessing that particular grant deed, that transaction, they already sold out to third party. So what happens is the new owner gets this tax bill and it's like, wow, where did this come from? And it's not theirs, it's the previous owner. It's just that they sold out so fast, the investor, that the title company, it does not show yet on the preliminary report, because title companies are only responsible for what's a public record and what is actually recorded in as a lien. But in this particular case, the tax assessor doesn't work as fast, and this particular buyer and the turnaround seller worked so fast that the tax bill now it was attached to the third owner, the new owner. So what that homeowner has to do is they have to go to the tax assessor's office, but not the satellite, to the one in downtown LA on Temple, and they have to take their grant deed or their closing papers, or mainly their grant deed, and show that they just came on title and that this particular reassessment, the supplemental bill, was triggered from the previous owner. And on those supplemental bill, here's the way, it states what triggered, the recording of the date of that deed, what triggered it. So that way your client, your new buyer will know. Another thing that happens, and we see it is real fast, is that when you're working with somebody who passed away, and the children maybe stay in the property for another 15 years, but they never record the affidavit of death, and then they go to sell, and then it's at the time that they sell that they record the affidavit of death first, and then the deed is going to go to the new owner. Well, what happens is that affidavit of death that is recorded before the transaction, the tax assessor finally gets a hold of that, and then that kicks a reassessment of the property taxes. But guess what? Now it's the new owner, and it's not their bill. But sometimes, if it's a little old lady that owned it for a long time and her tax is only $1,000, and now the new sales price is $6,000, the new tax bill is $8,000, obviously that poor buyer is going to go for a shock when they receive that tax bill. So again, they're going to have to go to the tax assessor's office downtown LA, if it's LA County, and show their grant deed, and what the tax assessor will do will take that tax lien off the tax roll, and that's when they put it again, and it's called the unsecured tax roll. And it'll go to, in this particular case, the estate of, or who the heirs, or in the case of the investor, when that tax lien comes off, it'll go to the investor. And guess what? When they go to sell or refinance, then it'll pop up. And then that's when they're gonna be responsible for that tax bill.
Okay, thank
I'm
you.
sorry.
No, it's okay. Okay, Marcus, really brief answers here. We're getting really close. Marcus, when are site inspections called for entitled?
Site inspections are called for when it's a high liability. So, and it varies from company to company, but I think across the board, whenever you're looking at a $2 million home, or at a home that you know that is next to coastal property, the coastal commission land that's owned by the coastal commission, or certain like public lands that it's right next, you want to go, the insurer wants to have a site inspection so they can verify the legal description of a property to see that there's no encroachments. And we will also call for an inspection when we hear that there may be an encroachment, maybe from the neighbor's yard, or their yard is encroaching something, some growth that they put, some shrubbery that they put in, or a fence that they put in is encroaching on the next door neighbor's yard, because we need to mark that as an exception to a policy. Because if a property is sold, if a property is sold and they have an encroachment, and then the new buyer comes in and it wasn't marked on the policy, and the new buyer is caused to now take that down, they can sue for loss of enjoyment of their property. And they're gonna sue the title company. And they're not gonna sue just for the cost of it. They're gonna, maybe it could cost $2,000 to bring down the structure. They're gonna charge us for loss of enjoyment, and it could be a $2,000 job that turns into a $50,000 claim. So that's why. And it's important to note, we do not insure to a structure. Title does not insure to a structure nor an address. We insure to a legal description.
Okay, great.
Can I add something? And I think Marcus knows this too, but when we do a site inspection for new construction, always.
Always.
Construction loan, always. We don't want any work to begin before the loan is funded, and we don't want any work still going on before we close. And we want to make sure everything is clear, that there's not going to be liability towards a new buyer. We have to understand that title company insures who? Not the seller. We're responsible to the buyers. They're the one that's being insured. So we have to make sure we protect their right, because they're the one that can come and sue everybody. All right, thanks.
Right, the buyers and even the lenders, if there's ever a huge increase in the value all of a sudden, if the home sold for $750 and a couple of years later we have, now $1 million loan on the property, we're gonna go do a drive-by, make sure, hey, did they do something new? Is it a bigger house now? What's going on? So Nancy, you're halfway through your coffee. I think you could answer this question pretty quick now.
That's what my coffee is.
What is a mechanic's lien and how does the title company deal with it?
Okay, I have one case right now. We're waiting for all the mechanics lien waiver, from the unconditional waiver from all the contractors and subcontractors. When you build something, everybody has to make money. You get this, the construction loan, the lender, if you're using a loan, the lender wants us to make sure that we protect them. But a lot of people also build with cash. When you start working on it, you have your general contractors, and of course, most of the builders do not talk to anybody else except the general contractor. General contractor puts a proposal in, all the costs of stucco, material, pavement, shrubbery, everything has to be on there. But we don't know if the subcontractors are getting paid. Does that make sense? So when a contractor finishes a job, it happened to me. You paid him. Did he pay all the subcontractors? We don't know that. So when you have a mechanic's lien, that means somebody has done work on it and they didn't get paid. Go back to new construction. The constructive period starts when the notice of completion is recorded. When the property is finished, the city inspection is done, the builder should go and record a notice of completion within 7 days. And the lien period for the right for the mechanic's lien subcontractor to file a lien is 30 days after the notice of completion is recorded. And that's the builder's responsibility, not the titles company. You have to do it. You have to provide it to us. We have to see of record. If you pass that deadline, you didn't do until a month, 2 months later, the lien period goes to 90 days. So between that period, anybody can come and put a lien on it that's done work on it. So if you close escrow prior to that, we got a problem. The buyer's gonna what? The mechanic's lien does not follow the person. It follows onto the property. So your buyer is inheriting all these mechanics lien. You know what? I feel sorry for the contractor, subcontractor. They have the right to make their money. So when they file lien, there's some bad ones, of course, but most of the time they did not get paid. My driveway was a contractor came and did my driveway, got a last minute phone call. The concrete guy didn't get paid for his concrete. So luckily, I haven't paid the rest of the remaining balance to the contractor. I told him to go jump somewhere. And so I paid the contractor, the concrete supplier myself. But you have to be careful when you do work, especially a lot of realtors have gotten the mechanics of it. When you do work for them, they do work for you, but they didn't pay the subcontractors. So those mechanics lien is an issue, a big issue for title companies right now. So we're very strict. For a lot of builders, what I do is when they keep building and they're good in good standing, I need their financials. I need their sometimes income tax return. I need an accounting for every job and the cost of every job. Otherwise, we cannot close prior to the lien period. Okay, so that's a very tricky thing. Working with the builders, agents needs to sit down with us first and find out what we need before you go ahead, and so you can prepare them. There's a lot of new builders right now, and they don't know what they're doing. It's not because their intent is wrong, but they don't know. It's a loss of priority. Mechanics, the work started when? A year ago. They didn't get paid. You sell it now. They have priority. That's why when you do a construction loan, it's better. The bank is making sure all the subcontractors are getting paid. Okay? So thank you very much.
Okay, all right, yeah, and if any of you are the contractors, builders, subcontractors, materials people, make sure you know and understand all these dates, because if someone doesn't pay off on that, you want to refile it in time, make sure you get your money. Unfortunately.